The Federal Equal Rights Amendment is being considered in the Illinois legislature. It's touted by its proponents as a simple amendment to the U.S. Constitution that would give equal rights to women. Sounds like a good thing, but Elise Boak with Illinois Stop ERA, you among others contend that the ERA is not what it appears to be, and that it is in fact a war on women.
The Equal Rights Amendment is presently put before us really is a war on women. It's a very poorly written amendment that, because it's so vague and broad in its coverage, would actually work against women by stripping away many of the protections and benefits that they enjoy today.
Like what?
Well, first you need to understand what the amendment does. It's simply worded, equality of rights under law shall not be abridged or denied by the United States or any state on account of sex. So with that very simple but vague and broad wording, what it does is it takes the classification of gender or sex and puts it into a category where you can no longer make any distinction in your government laws or practices, or even in some of your civic government laws or civic laws and practices, that make any distinction based on gender, so even when it makes sense. So if you think about it, for example, there are times when we say, wait a minute, there is a difference between men and women. For example, many times women are the main ones who are raising the children, and as such, they need special support in that role. A prime example is a government program called WIC, Women, Infants, and Children, where they provide nutritional supplements to low-income women and their children to make sure that they have proper nutrition, access to health care. And when you read through it, it's very much tailored towards women and their children from the ages of 1 to 5. Under an ERA, you could not specifically give benefits just to women and their children, because to do so would be sexist, and you're making a distinction based on gender, and the ERA would not allow that to happen. So something that has been very beneficial to women would be struck down.
And it's my understanding also that Social Security benefits and even child support could be at risk.
Absolutely. We've seen in states that have passed the same wording as state equal rights amendments, we have seen that wording, those amendments, used against women in cases that involved alimony, child support, a husband's responsibility to pay for his wife's medical needs. Those were all struck down, and the women suffered as a result in court cases. The Social Security benefits, the feminists have made it very clear that they feel that Social Security benefits for women who stay home and raise their children, they would be struck, because the feminists feel that these benefits violate the equality principle by encouraging women to be dependent. And so they would strike those.
Well, I thought the Equal Rights Amendment was something that really burst onto the scene in the 1970s, and now it's kind of fizzled out over the decades. But now it's being resurrected with vigor here in Illinois. What's the motivation behind that?
It's a political motivation, in part. There are politicians who feel like there's some emotional hype that they can bring up by saying, hey, I'm for women's rights, and even though this is a bad amendment for women, people don't realize that, and they think, hey, I believe in women's rights, so I'm going to get behind this amendment. So it's political in part, but there are women who believe that this is a good amendment for them and refuse to listen to reason that this amendment would actually harm us.
So they need to read the fine print.
They do need to read not only the fine print, but there are many analyses out there by legal analysts who have said that the impact of the Equal Rights Amendment would be total and comprehensive. There will be no ability to make any rational distinctions when it makes sense to help women.
Is this, and you've kind of alluded to it, but is this a way for the left to bring out the women vote for liberal candidates in the upcoming election?
Absolutely. It's an emotional issue, and we as a public tend to be too easily swayed by a soundbite instead of taking time to really get to know the issue.
It's my understanding that Illinois is part of an effort to bring 3 more states into line in passing the ERA amendment. What's the reason for that?
Well, when the Equal Rights Amendment died in 1979, there was still some continued effort to try to pass it with an attempt to extend the time deadline. When they realized that wasn't going to work for them, then they tried to introduce a new Equal Rights Amendment into Congress that didn't have a time deadline. The original one had a deadline of 7 years. They couldn't get enough states to ratify it. So when they introduced the new Equal Rights Amendment in 1983 without a time deadline, Congress wouldn't move it for them. At that point, we had become very educated on the problems connected with the Equal Rights Amendment. We had realized this was really not a nice thing to do for women. It was actually harmful for us, and so people refused to get on board. They tried that strategy for a number of years, then they realized that's not going to work for us, and so a couple of supporters got together and said, well, why don't we try to resurrect the old one? And so they came up with what's called the 3-state strategy, where they believe if they can get 3 more states to ratify it, bringing it to a total of, in their minds, 38, that they will take it to Congress and ask Congress to retroactively extend the time deadline on this amendment. And there is a resolution filed in Congress every session to that with that purpose. And so they believe that then they could declare this as a legally binding constitutional amendment. It's kind of like playing a basketball game, and the next day people waking up and saying, you know, we really didn't like the results, let's play a few more minutes, and whoever wins in those last few minutes, then we'll go with that final result.
So you think maybe they're on shaky legal ground?
They absolutely are. They have based their claim on 3 points. One of them is, well, none of them have merit in this case. The first 2 refer to cases where there was no time deadline set for the amendment. In this case, the Equal Rights Amendment had a time deadline that was part of the text. And 24 of the 35 states who ratified it made explicit reference to that time deadline. They felt that the 7-year period for passing it was important to pay attention to. One state, even in South Dakota, even passed a resolution that if the Equal Rights Amendment was not ratified by 1979, they would withdraw their ratification. I think, and that's important because people felt like there needed to be a contemporary discussion on the merits of this amendment so that people were informed enough to know what they were voting on. Today, we don't have that awareness. People are back to just thinking, hey, I believe in equal rights, this is for equal rights, why wouldn't I support this? They don't realize the harmful impact that's connected with it. But in addition to the fact that the 2 points are without merit because their cases didn't have time deadlines attached to them, the third one is really important. The attempt to extend the time deadline with the ERA beyond the 1979 deadline, they were only able to do it by a simple majority. Now, it takes 2/3 of a majority vote in Congress to move an amendment out of Congress. So how can you go back and revise it without a 2/3 vote? It's also problematic because the Constitution makes no provision for revising a constitutional amendment once it's gone out to the states for ratification. And it would make sense that you couldn't take it back and revise it because you've already had states that have ratified it. So in a sense, they are like contract partners. And to go back and change that contract without taking it back to your partners who've already signed on is illegal. In contract business, you can't do it with the Constitution either. And yet the supporters are saying, we can go back and get 3 more states to ratify it. We won't let any of the states, there's 5 states that have rescinded, we won't let any of them rescind, and we're not going to let any of those 35 states have any more say in it, even though we've changed the amendment since they agreed to ratify. That's just really illegal and in violation of our Constitution.
Proponents say the ERA is needed, and they point to the Walmart case Explain. What are they talking about?
That's a case that took place a couple of years ago where a couple of women who worked for Walmart felt that they had been discriminated against. They wanted to file as a class action lawsuit in behalf of many women in Walmart. Rather than filing individually on the merits of their individual cases, they wanted this to be a class action suit. They took it through the court system, and the Supreme Court turned it down as a class action suit because they said you don't have enough evidence that this was systemic, widespread and systemic. They said your individual cases may have merit, but it has no merit for the whole system. And so rather than looking at that and saying, okay, then we better just take it as the individual cases, the proponents of ERA use this almost as just kind of a gimmick of we didn't get the class action lawsuit we wanted, that's why we need the ERA. But the ERA wouldn't provide additional evidence for them. It's not going to benefit them.
Well, a number of states have passed the Equal Rights Amendment. What are the results there?
There are 18 states who have state ERAs with similar wording, and we have seen in the 30 years since they passed these ERAs in their different states many harmful impacts on women. As I mentioned, the language of these amendments has been used against women in alimony, child support, husband support for medical necessities. It's also been used in Pennsylvania recently. They used it to disapprove the practice of providing women with lower automobile insurance rates than for men. Now, we all know that most women are safer drivers than men.
Well, that's up for debate, but...
Okay, we could argue about that, but most women are safer. You're going to see some outliers. And the insurance industry recognizes that statistic. It's a strong enough statistic that they have offered lower insurance rates to women. But somebody took this up in Pennsylvania and said, this is in violation of our ERA. You are making a distinction based on gender, and our ERA does not allow that. They took it before the Supreme Court. The Supreme Court said, you're right. You can't have this. And so they went back to the Legislative Assembly in Pennsylvania, and they said, it makes sense statistically to let women have lower rates if they've got a better driving record. So they passed a law that said we're going to allow this exception. Went to the Pennsylvania Supreme Court, and the Supreme Court said based on our ERA, this law is unconstitutional and cannot stand. So even when it made sense to make that distinction, they couldn't. Another case that took place in Massachusetts was in the prison system. They had a system in place where there was a harsher discipline system on the male inmate side than on the female inmate side because they said the male inmates were more violent than the female inmates, and so they had to have a different system on that side. A male inmate contested that, and under their state ERA won because, again, you can't make a distinction based on gender. So now the female prison inmates in Massachusetts have to be subjected to an equally harsh prison discipline, even though they don't merit it.
What will the implications of passing the ERA have on, let's say, homosexual rights and transgender rights?
Well, you can't make any distinction based on gender under an ERA, so therefore you cannot say marriage is between a man and a woman because man and woman are gender terms. This was recognized in the state of Hawaii, which also had a state ERA. They had their traditional marriage law overturned by the Supreme Court because it violated their ERA. The people they gave them a year to then pass another amendment to support that definition. But we have since seen in numerous other states that their state ERAs have been used in part in overturning state traditional marriage statutes. In reference to transgender issues, again, you cannot make any distinction based on gender, so you cannot say this is a boy's bathroom, this is a girl's bathroom, this is a boy's locker room or a girl's locker room. We would have to become gender neutral in all practices. I don't think many people are comfortable with that.
There are also some strong ties between the Equal Rights Amendment and abortion.
There are, absolutely. In fact, in the state of New Mexico, which has a state ERA, their state Supreme Court ruled that because abortion is unique to women, to restrict abortion and withhold taxpayer funding for elective abortions is a form of gender discrimination. And so in New Mexico, taxpayers must fund elective abortions.
You also contend that passage of the ERA will lead to a federal government power grab. How so?
Well, the Equal Rights Amendment gives the federal government power to execute this amendment. And so many areas that are currently under the jurisdiction of states, such as family law, many of the other areas that we've discussed, right to life, marriage statutes, all of those areas would now become under the jurisdiction of the federal government. And so you're going to have a huge shift of power from the states to the federal government. The federal government is far less responsive to the citizens than the state governments are.
So why have an Illinois legislature?
It's a good question. I would prefer to keep an Illinois legislature because they are closer to the citizens. They hear our concerns much better. We cannot allow that huge of a power shift to occur.
What needs to happen to stop the Equal Rights Amendment from being ratified here in Illinois?
People need to immediately contact their state representatives and let them know that they are opposed to passage of the Equal Rights Amendment as it currently stands. Those people who are for equal rights for women, I agree with them. I think we're all for equal rights for women, but there are many laws already in place that guarantee those rights, including the 14th Amendment, which promises equal protection of rights for all citizens. But if you want to see something more done with equal rights for women, write a new amendment that's got better language. But in the meantime, this amendment is bad for us. It harms women. It's a war on women. It harms our families and our society. So call your state representative. Let them know that you are opposed to passage of the Equal Rights Amendment, the federal Equal Rights Amendment.
Elise Boak with Illinois Stop ERA, thank you for joining us. And if people would like to get in contact with your organization, what should they do?
I'll tell them to contact me personally because I love to talk with them. My email address is ebouc7@gmail.com, or they can give me a call at 847-438-5044. They can also reach out to the Illinois Family Institute, who is doing a tremendous job at helping to protect women and support women in our rights. Or they can reach out to Eagle Forum. There's many organizations that they can reach out to.
All right, Elise, thank you for doing this interview and for the kind plug for Illinois Family Institute. For IllinoisFamily.org News, I'm Monty Larrick.
This has been brought to you by the Illinois Family Institute, promoting marriage, family, life, and liberty in the land of Lincoln. For more information, go to IllinoisFamily.org.